communications offence that bans speech that could cause likely psychological harm or serious distress. There's concerns the proposed laws shift the focus from the actual content of the communication, for instance, if it's indecent or grossly offensive, to simply how others might perceive it. Radomir Tylecote is from the Free Speech Union. Thanks for joining us, Radomir. I hope I pronounced your name correctly. What are your thoughts?
You did just right, thank you.
Okay, great, that's good. What are your thoughts on the, this new law commission recommendation? And I often am very wary about these sorts of things because I do feel like we're sort of sleepwalking into a more authoritarian society in so many other ways. And I really, really do worry when we start sort of trying to police speech, particularly when the focus is on the sort of what the person is perceiving, essentially.
Well, I think you're right. And there are a couple of different issues at stake here. So what the Law Commission is proposing, its new proposed offence, is definitely going to be a problem for free speech if it happens. That said, we at the Free Speech Union think that the Law Commission is right that the Communications Act, which is what part of its proposals are about, needs to be reformed. And one of the Law Commission's proposals, and we commend this, is that there's this particular section of the Communications Act which criminalises sending online, essentially, messages which are grossly offensive, of indecent, menacing character, and criminalises messages which are there for the purpose of causing so-called annoyance, inconvenience, needless anxiety. Now, this criminalisation in the Communications Act sounds very sensible because nobody wants people to be sending annoying or anxious-making messages. But the problem is that it's led to a lot of needless prosecutions, simply when people have been rude online, they've made un-PC jokes online. And so it's been, if you like, drafted into this whole campaign against free speech. So it's worth understanding what this has done, really. You may remember the so-called Twitter joke trial when a chap called Paul Chambers, following a tweet when he was clearly joking about blowing up an airport that was closed because of snow, he said, "You've got a week and a bit, otherwise I'm blowing the place sky high," on Twitter, even though the airport management had said it was not a credible threat. He was arrested by anti-terror police in front of his colleagues. He was charged with sending messages under that part of the Communications Act. And in his appeal, it was pointed out that if what he said was illegal, then when John Betjeman, for example, wrote "Come friendly bombs and fall on Slough," no disrespect to Slough, could John Betjeman have been arrested when he wrote his poetry? So, and there are all sorts of other prosecutions that have happened simply for rudeness and jokes online. So we think that the Law Commission is right to want to do away with that part of law, and it's very important to stress that because the government has not yet committed to doing this. But the problem is its proposals may make things even worse.
Now, I'm interested you brought up the Twitter joke trial, because this brings in a political element to it. Of course, the Director of Public Prosecutions at the time of that trial overruled the initial ruling to dismiss it, to bring it back into the courts, despite being a clear Twitter joke. Do you think that there's a political difference between the government and the opposition on these sorts of speech issues?
Well, obviously, we don't take political sides at the Free Speech Union, but we think in general, both of the main parties in particular need to better get to grips with the public mood in favour of moving away from this PC age that we've got into probably since the 1990s. So we haven't really seen commitment on either side to do away with the Communications Act. We're talking to whoever we can in politics to try to move the dial.
I suppose some people might say that people have a right to not be offended. People have a right to not see messages that might cause them upset or distress. What would you say to that?
Well, we don't really think that anybody has a right not to be offended. And it's good, I have to say, that the Law Commission state in their recent proposals that, as they put it, freedom only to speak inoffensively is not worth having. The problem is they then undermine this, and I think this is where many of our institutions have actually got behind this idea that they can protect people from the rough and tumble of debate, which simply has to be offensive sometimes and may cause what they call psychological harm. So in this new law, they say they want to do away with offence. They don't want to focus on offence anymore. They want to focus on so-called harm. But we're very worried that criminalising communications that may cause harm will be perhaps even worse than doing away with the Communications Act. And they try to define this psychological harm. So they say this would have to amount to at least serious distress. And in their words, that's, quote, a big, sizable harm, unquote. But that's not really a definition. So we've pointed out in some of our work that when, for example, Galileo and Copernicus said that the Earth revolved around the sun, that probably did quite a big, sizable psychological harm to many people because of their beliefs at the time. And this, in fact, it gets worse because they say that we should take into account so-called protected characteristics, like religious groups. And you can imagine what religious groups might do if they feel that their psychological safety, if you like, is somehow being abused.
And even
so we really don't think this is the
recently
way
in
to
an
go.
employment tribunal. I mean, veganism was counted